court's ruling is.
So could you share with us all of the whatever parts you think actually you would like to have admitted and
Absolutely.
published?
Yes.
I mean, can you do that from now on without me having to beg you to do that?
Your Honor, the court does not have to beg me for anything.
Okay, I mean, let's just have it be sort of a standard, which I thought would have been clear anyway, but is apparently not, that you make it clear to everybody what parts of what exhibits you want in evidence so that we can then, if there are evidentiary challenges to them, be able to sensibly discuss those. Is that something you can do for the court and for the opposing counsel in this case?
Absolutely.
Okay. So can you right now let us know so that while we're having our half hour, we can take a look at all of that?
Sure can, Your Honor.
All right. Thank you.
You're welcome.
And the objections, as stated already, generally were hearsay, confrontation clause, and authentication. There's not going to be a confrontation clause issue. People's Twitter posts are not testimonial. But with regard to authentication and hearsay, I don't know if
He can set the foundation, and he can
authenticate these.
I believe that.
Okay, maybe. All right, and then there may. Okay, so let us know. How are you gonna let us know that? Because can you email to everybody the portions, or how are we gonna?
I can give you the specific page numbers.
Okay, and everybody else has a copy?
Everybody has this. Yes. When you say everybody else has a copy, I'm not sure what the court means.
If you give page numbers, they have a copy so that they'll be able to easily find and look at what that is?
If they scroll, if they look at the
Do you
they
remember?
have.
They have a link. Do you remember which link it is?
Yeah.
Can you let us know that, or at least them know that?
I'll just yes, I can.
Resending it would be great, and then
yeah.
pinpointing.
And perhaps telling us where it is in the discovery.
No, she's going to resend it, which would be easier.
Okay.
Okay, so you will do that and be specific about what parts you want in. All right, Mr. Shart, you had asked in the midst kind of all of the objections that the court give an instruction about the blank box. Is that something that you still want me to do, that the box was blank at the court's instruction because we didn't at that point have anything establishing the date? Or
yes, I would very much appreciate the court giving that instruction.
And that was States 44, I mean, not States, I'm sorry, Mr. Stillwell 44.
I believe that's correct.
Okay.
I can check. I'll approach and look at the evidence and confirm.
Okay, and so I'll just tell them that it was at the court's direction that the box was blank because it hadn't at the time been established what the box meant.
Your Honor.
Will that work? Yes, no?
Yes, that would be great. Thank you.
Yes, ma'am.
Your Honor, that requirement of the court was not on the defendants. They objected to that box being shown. The state had no objection. So in as much as the objection leveled by Mr. Stillwell is what the court based that on, and the state did not have an objection, and the state actually explained what it was, and Mr. Stillwell could have very well put that date in the box.
No, Mr. Stillwell could not have at that point. There was an objection to it. I will give that instruction, and I'm also going to instruct that the state may not in any way attempt to argue that Mr. Stillwell was trying to hide anything by having that box on there blank. Understand? And I'm not saying you would, but just want to make that clear. Understand?
I think, yes, Your Honor.
Okay. All right, I would also, let's see. So we're going to deal with the Twitter feed issues and the reconsideration of Zachary's things. Anything else?
The additional crime scene photos
Your Honor,
from Mr. Atkins?
I don't know if we'll get to that or not.
Okay.
When would that be coming in?
not it.
Your Honor, those probably won't even come in until the next week or the week after
Well, they
next.
may not be
depending.
coming in at all.
Well,
but
if
you-
they are to come in, it would be in about 2 weeks from now.
Okay, and so like you said, or somebody said that the CADs with regard to those had already come in. Can y'all be a little more specific about what those are going to be crime scene photos of and why, like what crime scenes and why? I know, Miss Love, you said, oh, you put them back because of witnesses that you had to add back in. Can you give me a little more specificity about the?
So at the begin, you want to know the actual
Crime scenes.
Okay.
And then why did you have to add those witnesses back in?
Well, the why was when counsel for
Was it because you were establishing who lived at places and they were gonna object unless you brought the person in?
that was half of it. The other
Okay.
half was that they objected to any of the
Chain of custody, I remember.
right.
Anything
right.
beyond that?
Yes. So I'm pulling up the actual
Okay.
incident number.
I mean, if you want to just give me an address, like the so-and-so crime
But-
scene.
But these photos, Your Honor, were not produced in discovery.
I
No.
understand.
Okay,
I'm
thank
going
you.
to get to that. I'm just trying to get a little bit of basis for what we're even talking about.
So it was 717 Cedar Avenue. I don't have the date on that in front of me.
Well,
The-
one was 2014, one was 2015, one was 2019, as I understand it. Which was that?
That was 2014.
Okay.
And that was based on an objection about the Nibin hits. And then there was the 807 Prior and 193 Hendricks shooting, which I think was that was in 2015. That was one of the retaliatory shootings. And then there was the 2019 one regarding Milton Howard in Rayshawn Lucci Bennett's vehicle
Where?
on the road. It was, the specific address was,
This is something there was just testimony about last week. Yes, no?
oh yes, I'm sorry, I thought you. Yes. That was rhetorical.
Okay, well, in any event, you say you added witnesses back because of needing to establish who lived where and the chain of custody, I guess, for like bullets and shells and things like that. But if the photos themselves were never provided, which is what Mr. Adkins represented in his email, then why should they come in now?
Your Honor, so as it relates to the scene, we believe that it's relevant information that does not unfairly prejudice anyone, as the incidents themselves are very much a part of the discovery that we've provided.
But the crime scene photos aren't, right?
Your Honor, I believe I believe that they have not, but I will make certain that they've not. I believe that
Well,
they have
Mr.
not been.
Adkins represented that they hadn't.
And I have no reason not to
Okay,
believe
so
it.
you check on that in our 30 minutes or so that we're going to have, and you can let me know. All right, let's be back here at 1:20.
Your Honor,
Yes.
I know that Mr. Sprinkle had no more questions on direct by the state, so I will put in writing. He mentioned some phone calls, jail calls. The state mentioned with him, but they didn't put him in. I have some objections to portions of those jail calls, and I'll put it in writing for everybody. But I just wanted to make the court aware, just in case the state wants to, on redirect, somehow get into those jail calls.
Yeah, are you going to get into the substance of jail calls with Mr. Sprinkle?
Not today, no.
Okay. Ever with Mr. Sprinkle?
At some point, yes, after we get other, yes.
Okay, then, yep, go ahead and put those objections in writing.
I'll do it.
And one more thing, Mr. Steele, you sent over an email sort of setting forth an objection or a continuing objection, I guess, that you have to the testimony of Mr. Sprinkle about his investigation, and you base it on Davis versus State, 307 Georgia 746 from 2020, and also Adkins v. State, 301 Georgia 153 from 2017, and the law that's set forth in those about conduct of an investigation and an officer not normally, only in rare instances being relevant, but that it is relevant after, or its case law appears to acknowledge that it can be relevant after a defense has raised questions about an investigation. And yet you're saying at the same time that your co-counsel is asking Mr. Sprinkle questions about his investigation that you don't believe that it is relevant here because the defense hasn't challenged Mr. Sprinkle specifically. And that is, I appreciate that nuance, but my original ruling on that stands, so I'm going to overrule your objection. You may have a continuing objection to that. All right, see y'all back at 1:20.
Just for you to know, we speak with independent crime scene people, so the state just giving us this, these photographs, and then we have to review the evidence, and then go talk to the witnesses. It's a hassle for us.
So if she lets me know that these were originally provided, that's one thing, but if they were not, then they're not going to be coming in. All right, see y'all in 30 minutes. So the witness AS is going to come in, and I'm going to ask for now y'all not tape her while we sort out whether y'all can tape her during her testimony. Yeah, audio is okay. Okay. The witness stand, she's not being taped right now. Videotape. Come on up to the witness stand if you don't mind. Okay, go ahead and have a seat. And I understand from the state that you've got some concerns about your face being shown on the live stream. Can you tell me what those concerns are?
Just anything doing my job. I just don't want to have no parts in it. I don't want to be on camera.
Pull the mic down next to you and try to speak into the mic. So is it anything beyond just not wanting to be on camera? Do you have any concerns about your well-being or your safety?
Not really.
Okay, well then that's not going to be enough. And the law, sort of the given, unless there are particular circumstances, is that it be allowed to be videotaped. And I don't have a lot of discretion in that regard unless there's some reason that can be presented. So I fully understand you feeling that way, and certainly, as I noted before, the media can choose not to show her face, but I can't order them not to. Okay. All right. So do I need to hear from anybody else on anything?
Your Honor, one other thing that we wanted to bring to the court's attention is that previously the media did not have a problem with people that we specified not showing their faces.
Okay.
It was never, they had no problem ever. It was only objections from counsel for defendants.
Okay. All right. Does the media have an issue with just voluntarily not showing her face?
My producer said you allow her to show. I can't speak for the other.
Okay.
I'll say this, and also what the media had agreed to is that if they had an objection to not showing the faces, they were going to come on the Monday after Ms. Hilton provided them. So she provided this to them, I believe, last week.
I understand that.
And no one has voiced an objection to not showing this witness's face. So we asked that.
Okay. Let me hear from the other media representative who's taping right now. We can't really hear you. Speak up a little bit. I can't even hear what
She
she's
said
saying.
she objects, she'll rather videotape it. My producers text me and said they would like to show it.
Your Honor, may I also clarify something?
Hang on just a second.
Yes.
So were you saying something about not having gotten the notice?
No, I didn't get a notice, and I asked Ms.
Love.
She ignored me, and then she wasn't here.
Okay, so who sent the email last week?
So, Your Honor, I sent the email last week, Ms. Sylvia was not on that email.
All right, we'll put her on all the future emails.
But
'cause
she
she's
did ask for it on Monday, and I forwarded to her on that Monday.
on Monday. Okay.
And
Well,
she did receive.
if you'll go ahead and add her to the distribution list for all the future ones. And we will continue to follow the procedure that had been put in place previously, that the objections, if there are any, need to be made the Monday morning after the Friday emails.
Yeah, and Your Honor, I don't believe that representation made by the state is accurate, that the media are the only people that have the opportunity to object to this.
That's not what she was representing. I think what she was saying was that they had not objected before. Ms. Westmoreland, you wanted to say something?
Your Honor, I believe it's been clarified.
Okay.
Turning the page again. I just want to make sure that Ms. Smith has been instructed as a witness. My concern is that there's always rumors, and I just want to make sure that Ms. Smith knows that she's only to testify about things that she actually has personal knowledge of.
All right. Ms. Love, I think you know what Mr. Sharp's referencing. Have y'all had a discussion about? All right. Okay, so does any defendant want to, I think in the future, the test is supposed to be, you know, is it within the requirements of due process to cover or exclude? And a lot of these cases are about a defendant objecting to coverage or the media objecting to coverage. And so if the defendant or the media objects, I need to hear the basis for the objection, and then I'll make a determination based on all the different factors that are set forth in Rule 22. But anyway, I haven't really heard anything that would lead me to believe that the case law would support ordering that this witness not be videotaped. So, Ms. Love, do you want to take just a few minutes to discuss with the witness what you need to? Okay.
Where should I do it? Right here?
If you want to step right outside, that's fine. Yeah.
Your Honor, starting with Mr. Sledge's testimony, the court and I think everybody else is aware that as we referenced State's Exhibit 1AS or 444, my particular question to him after he started talking about his truth and his ability to tell his truth was using the guidelines if a acknowledgement that you signed.
Yeah, I remember. We don't have to belabor the point.
Okay.
He picked out several and listed the ones that he said were false, and they were 3, 4, 5, 6, 7, 8, 9, and 6-2.
Right, with the exception of about 4. Right, and then he said that he understood none of the sentencing
at the time.
Acknowledgments at the time.
Mm-hmm.
So, Your Honor, under 24-6-607, OCGA 24-6-607, Your Honor, impeachment by contradiction.
Mm-hmm. Well, that's not impeachment by contradiction.
Well,
that's who can impeach.
So, as I'm reading, and I know that it's who may impeach.
It's a different one. 621 is impeachment by contradiction. A witness may be impeached by disproving the facts testified to by the witness.
Right. The reason that I reference that only is because it was in the book that I'm reading from. There's a section that I'm looking at. So, particularly, a witness may be impeached by contradiction in several ways. Close questioning to elicit concessions of errors in testimony during direct, questioning a witness about the substance or implications of evidence already produced during the case to suggest contradictions, confronting the witness with his or her own contradictory prior statements, or calling another witness, or introducing other extrinsic contradicting evidence. Generally speaking, the admission of extrinsic evidence for contradiction impeachment is restricted to non-collateral matters, so that evidence that impeaches by contradiction and is not collateral can be both substantively admissible as well as admissible for its impeachment value. And that is coming from Baylor, Behler versus Hanlon, Hanlon, 199 FRD 553, and then the parenthetical is surveying numerous commentaries. Judge, with respect to Mr. Sledge, the reason that I began my statements to the court about what it is that he said, and will then go into what his lawyer said. When I asked his lawyer about plea negotiations on the heels of Mr. Sledge, not just saying he was told he could get up and tell his truth, but on cross-examination, he was asked repeatedly through the use of allowable leading questions. These weren't your words. You didn't write it. You didn't understand it. You didn't know what you were signing. You felt like you could come in here and tell your truth. You signed it regardless. I'm not directly quoting, but essentially, even though it wasn't true, you signed it. And things of that nature were elicited during cross. You signed it because you wanted to get out to go see your sick mom, things like that. You were in Fulton County Blues. That's the only reason you signed it. These aren't your words. These are only the state's words. So all of those questions were intended to attack the credibility of the veracity of the statement that Mr. Sledge made on December 28, 2022, when he signed the plea agreement. And Mr. Sledge acquiesced to all of those attacks, essentially asserting through his sort of obfuscations and running back and pulling back my truth. I don't understand. I don't recall. I don't remember saying that. That isn't true. And his pointing out at the state's request the factual acknowledgments that he now asserts were inaccurate or not completely true. He allowed himself and the cross-examining attorney to, in front of the jury, completely question or to undermine the credibility of the statement that he made and his own credibility at the time that he made the statement. So as the court has already instructed the jury that the inconsistent statements of a witness are also substantive evidence that may be considered against other persons on trial. Can the court hear me okay?
Yeah.
All right. So as the court has already instructed the jury that it can now consider that statement as substantive evidence, what we've seen is an attempt by the defense to destroy the jury's faith in the credibility or veracity of that statement made by Mr. Sledge on December 28, 2022. So when questions were posed to his attorney regarding Mr. Sledge's understanding of those acknowledgments and sentencing agreements, on the one hand, after he made clear that though he's a friend of both sides, he's a defense attorney through and through, Mr. Wright, though he did clear it up, he seemed to, his answers on cross-examination, there were some things that were not true. There were some things we didn't agree to. He was kind of vague with it, and it took belaboring point by point for him to even acknowledge, hey, number 3, number 8, these are the only two anybody took issue with. So at this point, Your Honor, I believe that the iterations that were presented to Mr. Wright and to his client per his words are important because it is further evidence that corroborates Mr. Sledge's understanding of and his understanding of the final plea agreement that is 1AS and 444Y, and his ability to effectively engage in and have an active hand in that final document that he signed on December 28, 2022. It points not only, it demonstrates not only the inconsistencies of Mr. Sledge's testimony, but his outright perjury regarding his purported lack of ability to have any say in what that final document asserted that he signed. It is illustrative of the fact that he actually did have the ability to tell the state what he felt wasn't true and what parts he wanted changed. And I think that our position is that it is relevant in showing or allowing the jury to judge the credibility of statements Mr. Sledge has made on the stand versus the credibility of the statement that he made on December 28, 2022. The statute that I cited earlier, it substantiates our position that the representations that Mr. Sledge made under oath on December 28, 2022 were part of a long and detailed negotiation and refinement that Mr. Sledge himself took part in. I think at this point, 24-1-104 might become relevant. That's the one I brought up earlier that didn't have any bearing on what we were talking about. But in as much as 24-1-104 speaks to the code section not limiting the right of a party to introduce before the jury evidence relevant to weight or credibility, we believe that this particular evidence allows the jury, it is pertinent evidence that they should be allowed to see, to understand fully what was put before Mr. Sledge, what he did dispute, what he did not dispute, and so that they can compare it with what he finally agreed to and make a better determination about the truth of the statements he made on December 28, 2022. I think that the argument that some of the statements, the allegations made by the state, those are things that one way or another may be asserted in any event. For instance, they caught nut down bad is a statement that we know is going to come out either through the person that said it, the person that relayed to law enforcement that they said it, or in his statement to police if he lies on the stand. These aren't matters that are so prejudicial that they should be kept from the jury. These iterations, if you will, the defense wanted to have us reference part of them, but pointedly objected when I attempted to have Mr. Sledge show or point out differences between a previous iteration and the final version. That previous iteration was not circled there. It's one that I have because I did not tender it as a marked exhibit. They actually objected to my calling it a previous iteration. And I think in attempting to keep from the jury, not just the previous iteration, but the number of them and the changes that were made and requested, and the changes that were not requested, as is reflected in 460Y, we're keeping from the jury very relevant, pertinent evidence that in no way substantially prejudices either defendant through its admission. So I believe that an instruction that these are assertions made by the state, essentially questions that they ask the witness, then defendant, are these true? I initial them if they aren't, tell me what changes need to be made, and that they are not to consider as true from this witness or take as statements by this witness anything that doesn't appear on state's 444Y, and that they should look at state's exhibit 460Y as substantive evidence of the defendant through his representative of what he was calling true and not true at the time that the state presented him the iteration that came just before it. So it allows them to put in context Mr. Sledge's factual acknowledgments and sentencing understandings that he signed.
I'm going to get copies made of all of these.
Yes, Your Honor.
All right, so just one. Oh, batteries. Thank you. All right, I've got some batteries.
Oh, did they go in
That
here?
might help with, I'll just put them up here. Yeah. It seems like your mic is out and you might need batteries. I don't know whether they take double A or triple A.
Double A over here.
All right, got a few of each. I'm just gonna set those right there. All right, so I think that, there's the 444Y one, which is the signed plea acknowledgement. That's sort of a separate type than all of the rest of these correspondences back and forth. And are you at this point saying, just so I understand, that like as to 460Y, you don't even intend to redact it at all?
No.
All right, help me understand what you're saying.
As to 460Y, I wanted to redact everything except the one email that Mr. Wright sent. I want to take out everything else before. I even think I included twice in that 460Y, the same email. So I would like to redact out all of that except the email from Mr. Wright to me on December 27th at 8:43 or thereabout at night, wherein he is making statements for his client. So they are statements of his client that number one is okay, number two is okay. And I say that under, I would call it an adoptive admission, but he is an agent.
It's an agent.
Right.
Yeah.
So he is stating, his client is stating, number one is okay. And in order to know what number one is, the jury needs to see what number one was that I sent to them, which would be the exhibit directly preceding, which I believe is 452. If I'm wrong, I'll make that correction. But the jury should see 452, wherein Mr. Sledge says that's okay. They should see whatever he wrote about 450, about number two.
Let me ask you something. I mean, is he really a party opponent anymore?
He was.
But is he now? Because admitting it in this trial now, is that an admission by a party opponent?
Oh, you mean in terms of the...
You're saying, this is a statement by Mr. Sledge's agent, which it is, but would that get admitted under the admissions by a party opponent exception to hearsay?
I wasn't admitting it under that.
So
I was just saying that they are statements of Mr. Sledge.
okay, all right, but under what exception do they come in?
They are Mr. Sledge's statements. He is a witness who was on the stand, who was subject to cross-examination. So in as much as they are inconsistent and contradictory to the testimony that he gave.
Okay. So I can see 444Y coming in as a prior inconsistent statement, because he definitely testified inconsistently once he was on the stand to what he said in that document, which admitted as factually true all of those things that he initialed.
Right.
So that's a separate item, and I'll hear argument on let's deal with that one. 444Y.
Is it my turn?
Okay, so don't talk about the rest of them until we get past.
Not yet, because I think this is kind of separate than the rest of them.
Okay.
Because it's a different type of document. So do you want to say anything else about that? You saying it's a prior inconsistent statement and it's impeaches him by contradiction.
Yes, and it corroborates the state's position and.
Well, I know why you want it.
Corroborates the state's position is not a hearsay exception.
Right, I understand that. Yeah. So why does that not come in as a prior inconsistent statement?
Your Honor, first, I just have to address one thing. And I'm sorry, I'm not trying to be a whiner. This is exhausting because every time we are on the same page and Your Honor seems to direct us, things somehow get relitigated. We were up at the bench and we all looked at 444
No, 444 is a different one, but yes, 451 through 6 and 460.
Are we talking about the emails right now? Or are we talking?
No, what I wanted to talk about right now is the actual final plea acknowledgement.
So I'll address that.
Okay.
We all talked about this and we determined what would be admissible as prior inconsistent statements. And the state was allowed to read and confront, and he acknowledged that he signed. So he never said he didn't sign those things. He explained it. But those factual acknowledgments on the 1AS, which I think is 444Y, were read into the record and fully litigated. And we not only heard from Mr. Sledge, but then we heard from Mr. Sledge's attorney for a day. And the whole process of how everything happened was covered ad nauseum. I think the jury gets it. And there's nothing that I would understand to be gained by admitting the paper copy of what was testified to and discussed over a week with, this gentleman and his lawyer on the stand, however many days it was, that hasn't already been covered. Additionally, Your Honor, of course, my stance would be, if it were to be admitted, it would not go back to the jury because it would be continuing witness. It would be, signed statements, written statements, and the idea that somehow, well, that deals more with the prior versions, but
yeah, let's not get to that.
Yeah, I won't get to that yet, but we've discussed this, and now we're back to arguing about it again.
I don't actually know that we discussed 444Y 1AS.
Well, the state sought to admit it at one point, is my recollection, and you instructed the state to ask about the ones he was denying, and they confronted him, and they said, this is what you're denying, factual acknowledgement, I'm using an example, 3, and then it was read, and then it was discussed, and then we went from one to the other to the other. The state was certainly not rushed in their examination of Mr. Sledge. So all this has been covered. There's no need to admit the the document into evidence at this time. And it's cumulative, but also it should never go back to the jury to begin with, so I don't even know what purpose it would serve at this point.
Well, we can deal with that later, what goes and what doesn't go and what's subject to a continuing witness objection. But it's definitely a prior inconsistent statement. Y'all were given an opportunity to cross him on it. He was given an opportunity to explain it. It can come in as extrinsic evidence.
Well,
That-
okay.
It's pretty clear law, I think.
Well, the other thing is, I don't know if he denied, the other thing is he didn't deny adopting it. He said, and he gave an explanation.
I know.
Right, but I don't believe that lays the foundation for a prior inconsistent statement. Him saying, "Oh, I did sign this, and this is why I signed it."
Okay.
And then, so.
Well, the statements on the document say every bit of this is true, and I acknowledge every bit of this. And he testified inconsistently to that with regard to the majority of it.
He did, but he never said at the time he didn't acknowledge it to be true.
I think he did. Okay, so to me, I don't know if the entirety of it or just the parts that he denies are admissible, but does it really matter?
It
If,
does.
1, 2, and 14 through 15 come in?
I'd have to really look at it, and this is, the state has not given us a proposed redaction, but
Do you propose to redact that at all?
No, and just as a
Well-
point of clarification, on the first day of direct examination, he specifically said that one was not true. He said that on the second day, he came back and said yes, but the first day he said no.
it's interesting that Ms. Love says that, because when she actually was examining him, she misspoke and said that he adopted number 1. So now she's saying he denied it. Yes, I believe that if we're going to admit them, if the state's not willing to redact it, then it should not come in.
All right, so
What is it that they're proposing that we redact, Your Honor?
the parts that he didn't testify inconsistently with.
So I believe that the document as a whole serves to rebut it's a contradiction. The document as a whole is a contradiction, impeachment by contradiction. It serves the other, the 3 things that he said he admitted, 10, 11, and 12. 5, 10, 11, 12, 14, and 15. Provide context to the types of admissions that he was willing to make. It provides context.
All right, well, didn't they watch a video of you reading out just the parts that he said were inconsistent?
Yes, just the parts that he said were inconsistent. And I believe that the document as a whole is evidence, powerful evidence of what the document contains, of the statements that he makes in the documents. I think it's evidence, the fact that he signed, the fact that the document exists, the fact that they can see what it is that he was looking at, and compare it with what it is he is saying on the stand, allows them to further assess his credibility. It corroborates what they saw. It corroborates his understanding of what it is that he was signing.
All right, if we're talking about is it an exception that permits his admission, it being corroborative doesn't get you over that line. So, yes, sir. Yeah. Now, it may be that what you mean to say is that the entirety of the document needs to come in because that's the only way they can understand it. Is that what you're saying?
Yes, I'm sorry for not doing it as well as the court did. When I say context, yes, it is the only way that the jury can fully understand the document and what was before Mr. Sledge at the time that he signed it.
The state's stance is that the jurors can't possibly understand one factual acknowledgement about a video, for instance, without being provided another factual acknowledgement about gas stations on Cleveland Avenue. That acknowledgement about gas stations on Cleveland Avenue just sheds light on this acknowledgement about the video that allows the jurors to understand that. That's ridiculous.
You had him admit on the stand the factual assertions that he still agreed with, right?
I had him not read from the document.
Did the jury in any way hear the factual acknowledgments that he still acknowledged?
I believe that the answer is in some form or fashion they did. For instance,
hang on just a second, Ms. Love.
I'm objecting to the document coming in. And you said it, and I think the Honorable Attorney Sharp just said it. My memory, and according to my notes, the entire, from the swearing in of Mr. Sledge, then it skipped. And then the entirety of his acknowledgments, whether he admitted it or did not admit it, was read over my objection on a video audio from Crime and Law, or Law and Crime. And now we're doing it again. That's in evidence. So I'm objecting to it. It's already there. And the state at one time told you that they needed that evidence in because it shows demeanor and he had an opportunity to sit next to his lawyer, and that there was no one else in the courtroom, and Mr. Williams and I and the others weren't there to intimidate him or whatever their word was. This is just cumulative. He's been impeached. He's been thoroughly impeached. So I'm objecting to 444 at all.
And at the appropriate time, I'd like to respond.
The answer to your question is yes. It has been acknowledged.
So your recollection is that on the video, every factual acknowledgement was read?
That is, if I'm wrong, please correct me. I'm not trying to be wrong.
He's wrong.
That's according to my notes. There was nothing redacted. It went right from the acknowledgments, whether he agreed or disagreed. It was read by Miss Love.
All right, Ms. Love, I know you sent us an email at some point that said, here's what I intend to play.
Respectfully, Mr. Steele is incorrect.
Right?
We do.
Okay, so hang on. And was sent Friday, September 6th at 7:45 a.m. And then, yeah, I think that's the right date.
And what
then maybe again to me at 9:54 a.m.
Right. Would the court like that we put it on the screen or just reference the portions that we were taking out?
No. Oh, yeah, no, you didn't play the ones that he said were true. You only played the ones that he said were false.
Right. I know. Yes, Your Honor.
Okay. Okay, so.
And when the court feels it appropriate, I just had a couple of more words to say in response to Mr. Sharp's response about 444 and impeachment by contradiction and the amount of time spent on it.
All right, I'm not concerned with the amount of time spent on it.
Okay, then not that, but-
So the ones that are prior inconsistent statements are the ones that he said were false. So if you're arguing that the entirety of the document should come in, what's your basis? Your basis for that is it's the only way for the state to, the jury to understand what he was willing to admit to and what he wasn't later on. What's your argument as to why it should all come in?
So, Your Honor, reading from Morgan versus Morgan versus Covington, 648 F. 3rd, 172, 3rd Circuit. It's a 2011 case. The doctrine of, and this is quoted, this is cited from there. The doctrine of impeachment by contradiction serves as a means of policing a witness's obligation to speak the truth in response to proper questions and permits courts to admit extrinsic evidence that specific testimony is false, of course, because other evidence contradicts it. Other inadmissible evidence is admissible as rebuttal evidence where counsel opens the door to such evidence on direct or cross-examination. The doctrine of curative admissibility relates strongly to impeachment by contradiction. I won't get all into all of that, but when on cross-examination, Judge.
Appreciate it. All right, I'm going to give you your
Would you get that back?
documents back.
Thank you. Ms. Hilton's coming.
None of these are the, yeah, okay. Thank you. Sorry to interrupt. Good.
Yes, Your Honor. So we're not just talking about, if we were only talking about inconsistent statements, then that would limit us to a portion of it. But here on cross-examination, the entirety of the cross-examination was intended to present to the jury the impression that the statement itself was not knowingly or willingly or voluntarily agreed to. And in fact, even though the court sustained the objection to the question, I believe Mr. Sharp said it, or I'm sorry, forgive me, Mr. Sharp, Mr. Weinstein said it when he said, when the state put these words in your client's mouth. So the point of it is, when on cross-examination, whether it's effective or not, when the effort is, and the witness has allowed it to happen, that an entire statement is essentially sort of undermined. You say you didn't understand it, you lied because your mother was not well and you wanted to get out of jail. The validity of the statement itself is now, it's impeached. It's almost like you're impeaching the statement itself. You're saying that the statement isn't valid. And so in as much as the statement as a whole does allow the jury to understand, it does place the few admissions he makes in context. We'd ask that it be admitted as not just a prior inconsistent statement, but as impeachment by contradiction.
Your Honor, there's no contradiction. He said that the state presented me a form that they wrote on their letterhead and asked me to initial it, and I did. And that's exactly what the form is. It's a form that they wrote on their letterhead that they asked him to initial, and he did. So there's no contradiction. The document doesn't contradict anything he testified to. Now, there needs to be a hearsay exception. And the reality is, if they're arguing that things are prior inconsistent statements, they've already been played in the video, and we've already heard it. And if they're arguing things aren't inconsistent, then they shouldn't be played. There's no reason for the hearsay to come in. So even if I granted to them that it's a prior inconsistent statement, we've just established that we played a video with all of that being read, the jury's watched it, and that was covered. So at this point, that form for any hearsay exception that it would fall under, that's already been covered by the video.
All right, I'm going to rule on this one that the portions that he disavowed on the stand may come in as extrinsic evidence of a prior inconsistent statement. We'll deal later with whether they actually go out as continuing witness or not. So there's a relevance objection to essentially, I guess, all of what the witness might be about to testify to. And Mr. Smith, you were trying to sort of explain the relevance, and if you can just do it here.
Yes,
Whenever you're ready.
Your Honor, these shell casings that were collected at 1097 Harwell Road, this location is just down the street from Club Crucial. It happened December 26, 2014, and it produced a knifing hit to 2905 Springdale Road, which occurred on January 28, 2015. One of the other cases that the state has presented evidence on.
Okay,
and so, Your Honor, as we're talking about the shootings and the violence that has occurred throughout this investigation, the shell casings, the fact that there is this knifing hit, it just shows various locations. We're not going to say this person had it in their hands, but the fact that there are knifing hits to locations that are in close proximity to locations where we know where we
I have no idea why it's doing that.
Testing. Where we know that other instances that have involved the groups of people that are an interest in this gang war have been seen and apprehended at. We believe that it's relevant because it tends to show that this particular firearm was used in at more than one location and more than one incident. So the connection of the locations by shell casings is not like it's 2 years earlier or 20 miles away. The proximity and temporal proximity of the locations are what we believe make it relevant.
All right, and which group is it that is alleged to, that the state's theory at least, committed this,
So-
you said Springdale Road in this?
Yeah, so 2905 Springdale Road, yes, on January the 28th, which was,
Right.
and Your Honor, we are not going to always in each case be able to say this
Okay.
person had this gun.
Right, but I mean, was
but-
this alleged to be 2 YSL shootings
No,
or?
The 2905 Springdale Road, just one
Mhm.
second, was January 28th. Was the location of Miss Antrevia is a location of one of the witnesses that we have.
The Springdale Road.
Yes.
Right, and who is alleged to, or which group is alleged to have committed that shooting?
There was, during interviews, there was an allegation. The groups that were alleged to have been involved were the groups that are listed, YSL and F Gang. But
Okay.
I cannot say, there
So
is,
for the Blue Flame and then for Springdale Road, is YSL the group alleged to have committed those shootings?
not for Blue Flame, we don't know, but the
Okay.
Springdale Road, there was an allegation that YSL committed the Springdale Road shooting.
Okay.
We don't know who committed the Blue Flame, but we do know that the shell casings that were at Springdale Road were also fired at the, they are producing knife and matches to a location just a mile away from Club Crucial in the latter part of December 2014.
All right, and is this Club Crucial, or not, I'm sorry, is this Blue Flame shooting anywhere in the indictment?
No, it's not that it's in the indictment. It's just that it's the proliferation of violence and the location of the amount of violence caused by these weapons that have been used in these various shootings, we believe is relevant.
Okay, and is the weapon that matches both of these also, was it found in the possession of anybody who's alleged to be a YSL co-conspirator?
No. Let me make sure about that. Hang on.
Do y'all even have the weapon that these two things match?
No, we don't have the weapon. We have shell casings, but not the gun in this
Okay.
particular case. And so we don't, and we're in showing the back and forths, we're showing the amount of shootings.
Okay.
And
So I know that for a lot of the different incidents, there is a theory that, there is one shooting by one gang against another, and then the other gang retaliates against the first gang, and it goes back and forth, back and forth.
Right.
Is the Blue Flame shooting alleged to have been any part of that back and forth, back and forth?
we don't have that. We don't, in as much as we don't know who committed that, all that we know is that the weapons used there were knife and hits to.
Okay. So you just want to show that I assume we'll have some evidence that in some way ties YSL to the Springdale Road shooting, and you want to be able to show that somebody involved in that might have been involved in some other shooting, just to show that they shoot things up a lot, essentially.
Well, the count one of this indictment alleges exactly that.
Okay, but this isn't an overt act in count one of the indictment, right?
No, but it's
Okay.
it's not an overt act. No, the Blue Flame,
Okay.
no, but it is. I guess our position is it doesn't need to be an overt act to be proof of something that we are showing.
Okay, has there been any prior notice about this, any argument that it's 404B or intrinsic?
Well, we have not.
Yes or no?
No, I don't think we have, no.
All right, I'm going to sustain that relevance objection.
Yeah.
Yes. I'm going to exclude it based on relevance, 403, lack of notice.
Your
yes,
Honor,
ma'am.
Well, Your Honor, inasmuch as it has produced a NIBIN hit and that they have known, we have provided that information from day one. This is not something that has been kept. And inasmuch as it is a firearm that has been used in a shooting that we believe was committed by and perpetrated by one of the, or at least a member or associate of the enterprise that we're talking about for a reason
Okay, well, I asked you if you had anything that tied this gun to a particular YSL co-conspirator, and you said no.
Oh, I'm sorry, we said that 2905 Springdale Road is a location that we have heard from interviews that a YSL person shot up. We don't have a particular YSL person. And the fact that that same firearm was used less than a month, about a month earlier at a location about a mile away from where other YSL shootings occurred, we believe that makes it intrinsic. We've not argued, the court asked us, had we argued that? We had not argued it, no, but we do believe that it's intrinsic, it's definitely relevant. The jury could draw the conclusion that this same firearm was used in a different location. It would then be part of the evidence showing the nature of the enterprise that is described and alleged in count one. So inasmuch as the relevance, we believe, is that this firearm that we believe was used by a YSL member is used in another location, showing the level of the type of violence, showing the nature of the acts committed by the enterprise. We believe that it certainly meets the very, very, very low burden of relevance, and we believe it meets it. It's more than, the small burden required to be relevant.
Okay, well, maybe relevance wasn't the right.
And in as much as it's intrinsic, there's not notice that's required for intrinsic evidence. Evidence is just proving an element of count one. So there's no 404B analysis. There's nothing that has been argued or that suggests that somehow this would cause the jury to convict either of the defendants on grounds other than those alleged in the indictment. So we believe that it's relevant, pertinent, intrinsic, and admissible, and should not be subject to that extreme sanction of exclusion, given that this is something that has been, this particular NIBIN match, this particular information has been made known to the defense since the beginning of this case back in 2022. So we would ask that the court not exclude this information. And this is not a witness that is going to take a very long time. We have 2 photographs that we're going to publish. We have, I think, about maybe 30 that she took, but 60 that she took, but 2 that we were going to publish.
All right. Well, maybe I misunderstood a little bit about what Mr. Smith was saying at the bench. It sounded, and that may be my fault, I thought he was saying the NIBIN match was something that just got learned this week.
No.
So that was my misunderstanding. No. Maybe you just meant, I don't know what you meant. So you said something about things that had just occurred this week.
Well, we just put these witnesses back on the list. But no.
Okay. So I'll hear from the defense.
Your Honor.
Yes, sir.
Well, first of all, there's a lot of irrelevant police reports that are included in discovery.
Talk into your mic, please.
There are many, many irrelevant police reports and irrelevant incidents that are included in discovery. So just because the state put in discovery and we didn't jump up and down doesn't all of a sudden make something relevant or pass 403. Your Honor, what the state is not telling you, and quite honestly, I don't think they're being a little misleading. The 2905 Springdale Road address,
Yes.
that's in Trivia Smith's house. No one was ever charged with
That's what I
that.
just said.
There's no solid evidence whatsoever. The state wants to say, oh, well, we believe YSL is involved. They didn't say a name. They didn't say anyone that's allegedly did the shooting. They have no idea. And, you know, they also know from the discovery, if we're being honest about it, in the discovery, there's several references to Shell Kell shooting up 2905 Springdale Road. Nothing's funny about this. And the reality is they have no clue. The police have no clue. No one was charged with it. And now they want to bring in a separate incident that involves a man, it appears from me reading the police report, a man, Mr. Strozier, who's targeted outside Blue Flame, waiting on his wife to cash out. It's probably a robbery. Mr. Strozier has no relation that I know of to either YSL or If Gang or anything else that would suggest this is a back and forth shooting between the two groups. This has nothing to do with anything.
Your Honor, if I may respond briefly. Contrary to the belief, I guess, by counsel for defendant Stillwell regarding the information that we provided to the court heard me say, and I maintained what address was at that location. I started to say the name and then I chose not to say all of it. But it is alleged at that time that she had begun seeing Kelvin Watts. And this is the precipitation of the providing of that video where we see Antonio Sledge and Quindarius Zachary saying we ain't going back and forth. She provided this to the police after this shooting, right after this shooting. That's how she interfaced with Detective Dennis. So while a member of YSL, I think Mr. Zachary, said something to the effect of, you know, well, somebody said Shell Kell shot it up. But at the time that this shooting happened, she was dating Mr. Watts. And so there was, you know, it was said sort of sheepishly, the court can hear it, it'll come in, I believe, during other testimony. But the idea that I'm certain there would be a desire that everything that we put in here is considered irrelevant, but it's not, simply because an assertion is made by, you know, one of the accused that it's not relevant. It is in fact relevant. It does not, there's nothing that warrants its exclusion. It meets the very low requirement for relevance, and arguments to the contrary don't take into account the information I believe we've just shared with the court. And no one has ever said anything about the victim in this case. We're not bringing up his name. We're not trying to say he has anything to do with it. But guess what? A lot of the other shootings that occurred, for instance, the location of Miss B, she wasn't an intended target. And that's one of the themes here. We see people who aren't intended targets getting affected by the violence that's perpetrated by persons on behalf of this enterprise. And so in as much as that person's name, you know.
Do you have any evidence that the shooting at the Blue Flame was perpetrated on behalf of, at the direction of YSL?
Your Honor, what the evidence that we have that we believe suggests that a member of YSL was involved in that is a knife hit to the...
Okay. A member of YSL was involved in that is not the same as it was done at the direction of, in furtherance of YSL.
And Your Honor,
so
I get that.
All you have is that the gun used here
produced
is suspected to have was apparently the same gun used at the Springdale Road location, which is suspected to have been done by a YSL member, but could equally have been done by somebody who's not YSL, under the theory that, I mean,
Your Honor,
it's
it's circumstantial evidence.
right? It is circumstantial evidence.
It is
all right. Right. And I mean, yes, you can prove your case based on circumstantial evidence. You have a right to do that. But I do not find that this Blue Flame incident is intrinsic to the issues in this indictment. So I am excluding it. All right. So does that mean that we're done with this witness?
Your Honor, if the court's going to exclude that one, then we'll.
Your Honor, can we just have a instruction to the jury to just strike
yes.
the testimony about this incident?
Well, they hadn't heard much of anything yet anyway, but yes. All right.
Your Honor.
Yes.
Your Honor, I would ask that, given that the court has decided that it has not heard very much, there's nothing that's prejudicial to anyone that's been presented. We would ask that the court simply allow the state to have no further questions and move forward. They haven't even seen the photographs. And so to strike the information, there's nothing that has been in any way that could, they be considered harmful. So we'd ask that.
Well, it's not harmful, but I mean, we don't want to be confusing the jury, so I'll just tell them to disregard it. You can certainly put her back on the stand and say, thank you, no further questions, but then I'm going to turn around and say, disregard all that testimony. Yeah. If you want me to say it in a way that you want to come up with a particular way for me to potentially say it, I'm willing to consider it.
Just one moment, Your Honor.
Okay.
The court will allow
Anybody
us.
need to use the restroom while we're on break anyway? Yes. Okay. And gentlemen, you will notice that there's a different witness in front of you right now, and I'm going to instruct you at this time you are to disregard the testimony of the last witness. If you'll swear this witness for us. Miss, is it Parks? Will that work, or just Miss? Okay, come on up. All right, so I know that you have been live streaming pretty much this entire trial, and I'm sure probably the pretrial proceedings as well, and it came to both the court's attention and defense counsel's attention recently that you had been on your, what do you call those things that you do? It's not a podcast, or is it, do you still call it that?
It is a podcast,
okay.
But it's
a video podcast. Okay. Anyway, we'll call it a podcast. Okay. That you had been, and I know that you say in your letter that you didn't reveal any personal identifying information. And I think that you did not reveal enough to actually identify any of the jurors, but you were referring to where different people sat and their race and gender. And that is personally identifying information. And then you were giving them derogatory names. And you say in the letter that you provided to me this morning that you have always operated with great integrity, that the content you share represents factual reporting, and that you do your reporting with the, and these are all quotes from your letter, the utmost respect and integrity for all involved. Do you believe that any of those three statements that you made to me this morning is actually true about the names you were giving those jurors?
I just want to give you the names were movies that I like. And, SpongeBob is my daughter's favorite cartoon.
Do you think that those showed respect and integrity to the jurors?
Well, I didn't think it were bad names at all. Glasses, nose. No, I didn't think it was bad names. I should know all the names.
The utmost respect and integrity?
I think it's depend on the individual. Well, to me, I felt it was utmost respect.
Well, I do not feel that. Oh. That seems like the kind of thing that a kind of mean person does on the playground in grade school.
You think so?
I do. I don't think that shows the least bit of respect or integrity to the jurors or to the court system. So if you are going to, and let me ask you this, you talked in your letter about being media and freedom of the press. Do you consider yourself to be press and media and journalism?
I consider myself being a content creator. I create content for the community and give information. As far as journalism, I didn't go to school. I've taken some classes and things like that. But the information I believe is very vital for the community.
I don't disagree. I mean, this is court. It's one of the most important things we do in our country. But you say my role is to deliver news and information. So, I mean, do you, to that extent, and you say you want to represent factual reporting. So do you, to that extent, consider yourself to be media, even if it's non-traditional media?
Yeah, I would think I would, because I've taken courses of etiquette and things like that. But as far as and then and the other thing too with my channel, it's more like some sort of like easygoing, friendly type of thing where people don't feel like it's just.
I'd love for you to keep it friendly.
Okay,
that would be great.
Okay, and I will never use the names anymore if it offend anybody, because that was never my intention to offend anyone.
Okay,
I was just using names of movies that I like, Twister, SpongeBob, Ghost, things like that.
I mean, I realize that if you're trying to create content that fills, the entirety of every day, that sometimes you probably have to reach out somewhere to whatever pops into your mind at the time. But I would ask that before you do that, that you actually do keep in mind that this is a court proceeding. And I know a whole lot of people seem to be watching this as entertainment, but this is not entertainment for any of the people involved here. This is very serious. And it does a disservice, I think, to everybody when the coverage is flippant in the way that I think that was, okay? And I know you've got every right to do that if you want to. I would just prefer that you not.
I won't.
And I am gonna give you this, it's a code of ethics that the Society of Professional Journalists follows as a guideline.
Okay.
And I mean, you're not required to abide by it. It's not the law. But it might be helpful for you to take a look at it and just, use it as a guideline.
I definitely will.
Okay, so if you can do that for me and try to be respectful and treat this with integrity, then you may come back in and continue to live stream.
Definitely.
All right, I appreciate it.
Thank you, Your Honor.
Hand this up to you.
Okay.
All right, I don't know if y'all have had an opportunity now, we can get back to our issues with, or potential issues with some of the exhibits that may be used during the cross.
Yes, Your Honor.
All
With
right.
the court's permission, may I maintain my seat there, because I'm looking at.
You may.
So in the Dropbox that we received from Defendant Williams, included are what appear to be, and I'll just take them in turn, exhibit number 15 alpha for Defendant Williams appears to be a video of LeBron James dapping up someone and wiping his nose and saying slime.
Okay.
We object to that.
On what basis?
Relevance grounds.
I suspect the relevance is gonna, well, I don't want to speak for you, Mr. Steele. What's the relevance?
It just shows that this is not unique to YSL
Okay, well,
or in a gang. Also, Your Honor, it's already in evidence.
It's already in evidence anyway. It's already in evidence.
That's possible.
It's
Probably, it
already
may
in
have gotten,
evidence.
that may have been the case, and if
Yeah,
that's
if
the case,
it's not, I
I'm
can see. I'm
Okay.
going to overrule the relevance
Okay.
objection to the extent it's not in evidence.
all right.
Any other?
And yes, there are apparently, so I'll name them again, 16 alpha from defendant Williams is a person unknown to the state, a random person in what appears to be a TikTok video. And this person is, they're singing.
Okay.
Apparently they're singing defendant Williams' song.
Okay.
And they're saying, and he's saying slat, 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 slat. They're lip syncing to it. It's a young female wearing a skull cap, lip syncing to defendant Williams' song.
Which number is this?
Okay, in the beginning, there's no skull cap. She's just got
okay,
her
and she
hair
puts
straight
one
down.
on. Okay.
And then later on, there's a young lady in a skull cap. We object on 2 grounds: relevance, and in as much as it is defendant Williams' statements, his statements, we would object as self quotations.
I don't understand the
there is no objection
or
that is evidentiary objection that is self-quotation.
Self-serving hearsay. It's hearsay, Your Honor, and there's no exception for it. So I'll leave it at that.
It's non-hearsay. I'm not using for the truth. I'm just showing what exactly. Now, Mr. Sledge said that slime is just used. Slat is just used. He said it's used by people all over the world. He said people can say YSL, they're YSL. There's no initiation. I don't know, though, Your Honor, if he has seen these before. So
the what? You don't know what?
I don't know if I could lay a foundation. I don't know if he's seen these before, so I would show it to him beforehand.
So, I mean, if this is an exhibit that's showing somebody lip syncing to one of your client's videos where he uses whatever this terminology is, that doesn't establish anything other than he put these things in a song and people sing his songs. That doesn't establish that she or anybody else would have used that terminology otherwise. So I'm going to exclude that. That does not show what you allege it to show.
I think that goes to potentially weight, but I understand the court's ruling.
Additionally, Your Honor, 16 Bravo from defendant Williams is a video that I think it's safe to say has not been tendered previously. And it is, as it's loading, it's a young man whom we don't know the identity of, who is, I think, either singing or lip syncing. He's lip syncing defendant song.
All right, let me say that anybody who is just some random person lip syncing or singing a song that Mr. Williams put out does not establish anything other than once he puts out these songs, people like the lyrics and sing the lyrics, and that doesn't establish anything other than that. That it is now in common parlance in the music business is probably not even an issue.
So I think that is the case for 16 Alpha, 16 Beta, 16 Charlie, 16 Delta, 17 Alpha, 17 Beta, 17 Charlie, 17 Delta.
No, that's wrong. So it would be under 16A through F would be consistent with this honorable court's ruling. I will not attempt to introduce it. 17A through E, some of them have already been admitted. Other ones are similar. It's just people who are using the nose wipe, if you know what I'm talking about, the finger across the nose.
Okay.
And that's what those are.
And those are already in or no?
No, not all of them, but some of
And
them.
do we know when these came into existence?
Yes. Mr. Trontavious Stevens and Jeffrey Williams exhibit, or JW exhibit number 17A is already in evidence, and it's already marked 7 through E.
Judge, can we confirm that? Because I don't have that same memory of 17 Alpha.
Sure. And I guess at some point we really do need to sit down and sort out the evidence that came before me. But yes.
All right. So we do not have that same memory. And to the extent that it is not, if it is not, we would object on relevance grounds. It is an unknown person.
All right. Do you know when it came into existence,
Yes.
roughly?
We have the exact date. It's also 15. I think I said 17.
You
15A.
Oh, 15A is LeBron James, right?
30 in, and Mr. Kumo is getting the date, if that's okay.
So you already talked about 15. If it's
So 15A is not LeBron James lip syncing, is it?
it's LeBron
January
James.
22nd, 2024 was admitted into evidence.
Yes,
January 22.
Is he also lip syncing one of Mr. Williams' songs?
Mr. LeBron James is coming into a locker room. He has teammates. He's a basketball player.
Yep.
I know you know that. But,
I know you're setting up for the record. He's one of the most famous people in the world. Yes.
Is greeting his teammates.
Okay.
And as he's greeting, he's doing different type of greetings, and one of them is the wiping of the nose.
Okay.
That's what it is.
Okay.
Other people in there, and I have to look to get the exact numbers, but is a baseball player on the Padres. Last name is Musgrove, Musgrove. He throws a pitch on the diamond.
All right, ladies and gentlemen, I've got some further instructions for you with regard to some of what you just heard. So I gave y'all an instruction that if this witness provided testimony that was inconsistent with a guilty plea admission, that you could accept that guilty plea admission as substantive evidence against any of these defendants. But then what we heard was that this witness pled guilty in 2017 to that being a part of that 2015 drive-by shooting. But and we heard kind of a factual basis that the prosecutor in that guilty plea had read before the court, or somebody had read before the court, as a part of what Ms. Love was asking questions about, and she was, kind of reading it from a transcript. All right, here's the thing, is that guilty plea, as I think you heard this witness say, he entered that because he believed it to be in his best interest to do that. And this gets into a whole lot of kind of legal terminology and legal concepts, but there are a couple of different ways that somebody can say, yes, I'm pleading guilty to a crime. And one of them is called an Alfred plea. It's just named after a case called Alfred. But they're essentially saying, I am going to plead and accept that I'm guilty of this crime, but I am not saying that the facts that the state's putting forward are true. I am just saying I think it's in my best interest to go ahead and resolve it that way. So everything that you heard, and that is totally legitimate to do that. And let me also say that Mr. Wright, who was representing this witness at the time, he let the court at that time in 2017 know, hey, this is an Alfred plea. He's doing this because it's in his best interest, he believes, to do this. And Mr. Sledge was under no obligation after his attorney said that to, even if he got an opportunity to say anything else, to say, yeah, what my lawyer said, to add anything whatsoever to that. So I think there was a question about that, and he didn't, he didn't say anything else. He had no obligation to. He had no requirement to. He had no responsibility to, okay? So basically what I told you about, you can take those facts and those admissions and consider it against him or anybody else in this trial. When it's an Alfred plea, you cannot. So none of that I said was actually true about what you just heard about those 2017 guilty plea to the 2015 drive-by shooting, okay? So let me think what else. Oh, and you also need to completely disregard that anybody other than this witness right here, Mr. Sledge, might have pled to anything that had to do with that drive-by shooting, all right? So just entirely erase that from your minds. And I also, at this point, am going to admonish and rebuke you, Miss Love, to pay careful attention to how you ask questions and what you put before the jury. You should not have put that factual rendition before the jury as anything that this witness admitted to at the time of the 2027 guilty plea. And I'm going to instruct you to refrain from asking improper questions.
Yes, Your Honor. Thank you.
All right. Anything in addition that anybody needs to put before the court right now with regard to those curative instructions? All right. All right. Go ahead, Ms. Love.
Mr. Sledge. Would you tell the jury, just one moment.
Sure.
Whether you are familiar with a person by the name of Antonio Sumlin who goes by the name Obama.
I know of him.
How do you know of him?
Just seeing him around.
Have you ever have you ever hung
we probably
out
been in
with?
the same. We probably been in the same vicinity, but I never hung with him. He never been in a car with me. He never nothing like that.
What about Martinez Arnold?
Yes, I know Martinez.
How long have you known him?
I've been knowing Martinez Arnold. Whoa, it's been a minute. I can't actually tell you how long, but it's been a minute.
Is he a person that you know who also answers to the name Duke?
Yes.
All right. Is Martinez Arnold YSL?
He's an artist of YSL.
And what about Antonio Sumlin? Is he YSL?
I can't tell you yes or no to that answer.
Now, putting aside matters in 2017, as they relate to December 28th, 2022, at any point, did you make an assertion while speaking with the state through your attorney that YSL is not a gang?
I don't think I made it in that plea agreement, but in 2015, okay, right.
In 2022, December 28th, 2022, at any point, did you assert that YSL is not a gang?
No.
At any point, did you assert that YSL members, that you are unaware of 3 or more YSL members who have committed crimes intended to increase the notoriety, street credibility, and reputation of YSL? At any point, did you make that assertion?
I don't remember.
Is there anything that would refresh your memory?
Yes, if you have anything that can refresh my memory.
What do you believe would refresh your memory?
I can't say whatever you have. If I can look at it or go over it, and then I can.
Yeah. Would looking at 444Y refresh your memory?
Yes.
Your factual acknowledgments, okay. Approaching the witness with 444Y. All right. Have you had a chance to review it?
Yes.
Does it refresh your memory?
Yes.
Okay. So at any point, did you assert that YSL is not made up of 3 or more members or associates who have committed crimes to increase the reputation of YSL?
I misunderstood that question because from our understanding, y'all say 3 or more people that commit a crime is a gang.
Why do you keep tying the state's understanding to your answers?
Because that's my understanding. You can't. That's my understanding. When I was arrested, that's what Gator and Dennis, not the state. I'm sorry, Detective Gator and Dennis provided us with, which they probably misled us.
And so when you say that's what they provided us with, what does whatever it is that you're speaking of have to do with your acknowledgement that YSL is made up of 3 or more people who've committed crimes for YSL? What does one thing have to do with the other?
I don't know, Ms. Love. I don't know.
Assumes the evidence is coming in, and I don't make that assumption since the motions are still outstanding.
I'm trying to cover things in terms of eventualities and, conditionally and things like that. So I understand that. I hope you're not chewing gum. Are you chewing gum? Okay, great. No chewing gum in class. All right. So it's my understanding that everybody has joined in the position that Mr. Copeland's testimony was coerced based on what occurred during the June 10th ex parte. So, and yet I know at least some of you want that testimony and said that yesterday. So are you waiving the issue of its potential coercion?
Good morning again, Your Honor. I am not waiving that
All right,
issue.
so then how do we handle that?
I thought it's two-stage. I was answering your question. If Mr. Copeland's resumes testimony, then my understanding of the rule is, or the law, is the way that the court announced, and I think all parties understand it, that once that motion by the Honorable Douglas Weinstein was filed on the 12th, everything thereafter is excluded, and we redo it. And that's what we, Mr. Atkins sent an email last night. That's what 3 of us responded to. I don't want to waive, though, the issue. I thought we should have a hearing with Mr. Copeland to determine did that in camera, if it's in camera, ex parte rather, June 10th meeting, did you feel intimidated, coerced under the Archer case, which from Maryland, I know it's from Maryland,
Right.
that we discussed? And if yes, we were going to ask you then, if a witness was intimidated, that he should not have to testify. He could choose what he wants to do, and then we would strike everything he said.
Okay, well then let's go ahead and find that out. I mean, can you get him here so that we can explore that issue? Because here's the thing, is that Yeah, if everything after June 10th, whether the recusal motion was filed or not, that's kind of a separate issue from whether his testimony post June 10th ex parte meeting was coerced. And if it was coerced, then what then? Then how do we still say, oh yeah, but I want, some of that testimony? That's still good.
I thought you, and listen, I have so many, going on. It's just the reality of our case.
Yeah.
But I thought you said that either yesterday or last week that we will find out whether Mr. Copeland actually wants to continue testifying. And then if he doesn't continue testifying, my understanding of the law is then he would never have been given an opportunity to be cross-examined.
Right.
And therefore you strike all of his testimony. Then you give the command to the jury that wipe out everything that you heard, saw. There were writings introduced, all exhibits are struck, give me your notes.
Right.
That's what I thought. Now,
okay, I just didn't understand because, and thank you for clarifying, because what I was trying to sort out is, are y'all kind of taking the position, it was coerced, we have to redo all of it based on the coercion, but then also, yeah, we want to keep parts of it anyway. So if it's a yes, if it was coerced, then we need to redo all of it, or find out, does he at this point kind of redo are you intending to take a stand and testify, or are you going to be held in contempt?
That's what I thought.
Okay, all right. Just so sounds like then we're on the same page. Just wanted to make sure y'all weren't wanting it kind of both ways. Ms. Levy, you look like you want to say something.
I was trying to get a full grasp, Your Honor, on everything that was being said. And when I hear that we're looking into whether or not his testimony was coerced, of course I'm going to defer to the court. I would object to that for several reasons. One of which is that the court has had an opportunity to review what went on there. And I believe that based on what is there, right there, on the transcript, the court can see, and I believe could make a determination that there's not coercion. So based on the way that the witness has conducted himself, and based on the concerns that we have expressed, the concerns that the witness expressed during prior interviews before I even came onto the case, I would ask that the court not revisit or go back and see, have a hearing on whether or not he felt coerced.
Okay, so this isn't a revisiting of the issue because the issue is live and still pending before the court in Mr. Kendrick's motion and supplemental motion for mistrial, and in Mr. Shart's, on Mr. Stillwell's behalf, revised motion for a fair trial. That's a big claim in both of those motions. And I mean, I just gave you to Friday to respond to them, but, and yeah, I think that on the record, it's a legal determination to be made. We don't necessarily need to hear from Mr. Copeland because I'm not sure about Mr. Copeland's credibility on anything anyway, but.
And so for those reasons, I would ask the court to not have us bring him in before that time that he has to testify. I'd also point out that his counsel was present.
I know.
So thank you for hearing me.
Okay, well, I mean, I hope that it is not up for debate, that some of what was said to Mr. Copeland in terms of potential ramifications if he didn't testify was incorrect. I don't think that there was any kind of, purposeful or nefarious motive in that. But I mean, at least with regard to the notion that he could be held until the trial of even the severed co-defendants was completed, I don't think is a correct statement of the law. If you believe that it is, then please provide me with what you're basing that belief on. But I mean, I also don't think that he paid much attention to that at all. He doesn't even seem to have, I mean, he kind of basically moved on from that, but that was incorrect. I think that some of the assertions about statute of limitations potentially were incorrect. I don't think that with regard to he seemed to be worried about a particular crime, the statute of which had apparently already run. But I think that in terms of the notion that he faced no potential jeopardy with regard to crimes based on statute of limitations. I mean, there's the immunity issue, which is wholly separate, but y'all are basically saying you don't even have to worry about it for the statute of limitations reason. They're saying, well, then how are we sitting over here charged with RICO for crimes, the statute of which, when the statute has run on the overt acts, they're in support of the RICO.